Okay, let's get started. Good afternoon, everyone. I'm Prashant Tomar from Baker Tilly, India, and I will be your host for today's webinar, Staying Ahead of the Curve, DPDP Act Readiness for Enterprises. Thank you for taking out the time to join us. We are delighted to have you with us and look forward to an insightful and engaging session today. To ensure a smooth experience, please note a few housekeeping points. All participants will remain on mute during the session. If you have questions, please type them in the Q&A or the chat box on your right-hand side. We will be addressing all the questions at the end of the session. Please note that we will be recording this session and the same will be shared with you after the webinar is over. Okay, before I get started, I would like to briefly introduce our organization and the work that we do. Baker Tilly ASA India is a leading accounting and consulting firm. It is a member of Baker Tilly International, one of the world's top 10 accounting networks. With over 3 decades of experience and a team of 1,200 plus professionals across India and abroad, the firm provides end-to-end advisory service in M&A, assurance, accounting, tax, risk, regulatory, cybersecurity, and ESG. Since joining Baker Tilly International Network, ASA has significantly enhanced its global reach through access to over 700 offices across 143 countries, supported by a network of more than 43,000 professionals worldwide. Today's webinar on DPDP Act could not be more timely. As India moves towards a more robust data protection framework, the Digital Personal Data Protection DPDP Act 2023 brings with it a host of responsibilities for enterprises across sectors, from understanding the consent mechanism to managing third-party risks. Organization needs to be well prepared to stay compliant and ahead of the curve. To help us navigate these critical challenges, we have with us a panel of experts who bring legal, cybersecurity, and regulatory perspective to the table. So here is I will start with the session with Medanshu Mishra, who leads the legal compliance and risk functions at Noida International Airport, India's first 100% privately owned greenfield airport. A law graduate and a fellow company secretary, he also holds a GDPR certification from the International Association of Privacy Professionals, which is IAPP. With over 2 decades of experience across legal, compliance, privacy, and risk domains, Mitanshi has played a pivotal role in navigating complex regulatory environments. His professional journey reflects a strategic shift from pure legal advisory to a broader risk management leadership role. He has been actively engaging in shaping data protection practices, keeping pace with global regulatory frameworks and industry trends. Our second speaker today will be Sri Krishna Dikshit, partner at Baker Tilly ASA India. He is a digital and cybersecurity expert with 20 plus years of experience across banking, ITS, manufacturing, and telecom. Sri Krishna has led 250 plus projects in information security, business continuity, and cyber risk management. A certified CISA, CISM, and CDPSC professional, Sri Krishna specializes in SOC setup, data security frameworks, and compliance with ISO 27001, GDPR, PCI DSS, and SOC2. Our third speaker is Rachit Shukla, Executive Partner, Digital and Cybersecurity at Baker Tilly ASA India. With over 15 years of experience, he has led data privacy and security programs at NPCI, RBS, and LeasePlan. His expertise spans ISO 27001, GDPR, CCPA, DPDP compliance, fraud risk management, operational risk, and business continuity. With that, I'm handing over to our first speaker, Medanshu Mishra, Head Legal, Noida International Airport. Over to you, Medanshu.
Thank you, Prashant. I hope I'm audible, loud and clear. Thank you to my fellow panelists. Good afternoon to all participants. and I hope this next 1 hour turns out to be a fruitful discussion. I've been given the difficult task of setting the context, which I will attempt to do with all humility in the next 10 minutes or so. The way I look at it is, if you look at the theme of this, why the DPDP Act matters now. The second element is what is the overview of the digital data landscape and what's the compliance urgency. Now, let me try attacking all of these three. The first question is, why does the DPDP Act matter now? With all due respect, I think it's no more a question of if, it's a question of when. DPDP Act has already been there since 2023. We all know that it hasn't been notified. We still await clarity on the rules. We await clarity on roadmap. We await clarity on timelines. So there's a bit of ambiguity, of uncertainty. What is worth pondering, or what is worth introspection, is that this landmark judgment of Puttaswamy, it came out in 20, which really mandated that we should have a very comprehensive codified legal framework around personal data and privacy. Now, today we are almost 8 years down the line, and we are yet to see the dawn of a so-called robust framework. While other mature countries across the globe, they have come up with GDPR and their own framework in other countries. So we have a bit of a catch up to do. We all know that legislative and executive machineries can be slow, but think about this. By the time we have the full roadmap, or by the time we are fully compliant with whatever framework comes our way, it will be almost a decade since that landmark judgment of Puttaswamy. In that time, the technologies have evolved. There is a rapid explosion of data that has happened across. Technologies are changing overnight. So the question really to be asked is, are we too slow on it? Are we missing the bus? That's the first thing I would leave the audience to think about. At the same time, what we have right now is a so-called regulatory vacuum. And when I say regulatory vacuum, I really mean within inverted commas, because what we really have are our own archaic SPDI rules which govern the personal data and the mechanisms they are under. So this is something to be deliberated and thought through. For the second aspect of digital data landscape is concerned, I don't think I need to enlighten the audience much. The audience will appreciate the fact that probably we are the largest data generating nation across the globe. And if my numbers are correct, I was just looking at the UPI details, and what I saw in the month of June of this year was 1,840 crore transactions in a month. In terms of value, it was almost 24 lakh crores. So for just sake of comparison, that's all the entire GDP of Maharashtra in just 1 month that we're talking about. So the digital data explosion that I was referring, it's the reality. It's in our face. Now, when you have that kind of a data explosion and that kind of a digital footprint spanning across sectors and industries and ecosystems, obviously the criticality of the personal data, the way we handle, the way we make it safe and secure, things like identity theft, profiling, fraud, and now we have fancy terms like digital arrest as well. So really talking of some landscape here. If you look at the evolution of the whole thing in the last few years, now even though I said we are living in a regulatory vacuum where our framework may not be as robust as it is, as it should be rather, but at the same time, when you look at the boardrooms, when you look at the projects, when you look at the companies, you see conversations going around. And when those conversations happen, there are concerns around individuals, around privacy. So those concerns as well as conversations are very well in our face. You can see conversations happening across the globe. I mean, one obvious thing that comes to my mind is the Apple ecosystem. How there is a conversation going around to be the gold mine of, or rather, the standard individual at center and with inbuilt privacy by design. But the contrarian conversation that is going on across the globe is that is stifling innovation. So in reality, those conversations are around protection of individual while at the same time not stifling innovation and governance around that. So we have enough examples of that. We saw that the Air India at Ahmedabad, and then it initiated a thread of conversation about installing cockpit recorders. Obviously, the pilot unions are opposing that because that has its own privacy issues as far as pilots are concerned. Those kind of conversations are there. Question is, what are we doing in our own companies, in our own boardrooms, in our own leadership meetings about these issues? And at times, and let me digress a little bit and talk a little bit in the context of airports, many times we think of benchmarks like Apple and the competition like iOS and Android, but we forget about our own things that are homegrown and they're there. For example, in the context of airports, many of us would have used the DigiYatra app. DigiYatra framework is a good example of privacy being at the center of it all. Now, those of you who would have installed the DigiYatra app and who would have recorded their concern would recall that the screen that appears there, it refers to a privacy policy. Of course, that's the easiest thing to do, just to refer the privacy policy and say that I'm hereby giving the consent. But what DigiYatra does is, on that screen, you will also see pointers which give you a good idea without referring the details of the privacy policy, which will tell you that okay, what kind of my data will be used by DigiYatra, who will be the user. It tells me that DigiYatra airport will be using that data. It will also tell you the data will be retained only for 24 hours from the time of flight departure. So that to me sounds like going beyond what the law is and simplifying things. And so even as a passenger, and to be honest, I have never gone through that privacy policy, but I'm aware of the those points on the screen. Those really, I think, are things to be appreciated. And of course, there is a whole digital architecture and digital framework around DigiYatra, which is an example worth studying to see how privacy is inbuilt into those kind of. When we ask the question as to what is the urgency of the compliance, I would say there are two aspects to that. One, DPDP is going to be a reality today, tomorrow, or day after, we don't know. Second, with all the experience that we have with other regulatory mechanisms, companies don't always have the luxury of time when it comes to compliance. So, although we have the statements of responsible government officials saying that there will be timelines, there will be a roadmap that will be provided, companies will have sufficient time to comply with that. But once we know that once it rains, it pours. So once it's there, it will be a race against time. So what with whatever information we have, I think we have that bit of urgency where and things will many a times systems have to be configured, the process have to be tweaked, the discussions have to be reinitiated, and all those things take time. From my personal experience, I can say that when the last organization, when we were implementing the GDPR requirement, it was one hell of a requirement there. Is already there, A, because of some kind of framework that is already there, and B, because the conversations happening outside, the conversations happening in the ecosystem, they are about this topic. People are interested in knowing how, as an organization, we are handling the data, how we keep them safe, and so I would say that even if there is no regulatory urgency per se, where the law doesn't prescribe a particular mandate as of now, but it will come soon. And for preparedness, I'm sure my fellow speakers will take the audience through the nitty-gritties of the law, the high level things that are to be done, how we can be prepared, and how what kind of assistance might be required at what steps. I'm sure. So I'll not go into the details of that DPDP Act. I'll leave that discussion to my fellow speakers. But as far as the next few 45 minutes or so are concerned, I will look forward to those insights, and I'll be interested in understanding those minor details. So with that, I think my time should be up, but I will hand over the baton to Sri Krishna for his insights into the topic. Sri Krishna.
Thank you, Midanshu, and good afternoon, everyone. So we will start with understanding the DPDP Act, the key insights and implications. Where we say what are the key insights of the Act. Year 2000 was the year of reform, wherein on 17th October 2020, 17th October 2000, notifications to IT Act was tabled in the Parliament. It was passed. Also, in 2007, Section 43A of IT Act was introduced, wherein it specified on the rights and responsibilities on use of IT assets and IT infrastructure. 2023, of course, we all know that DPDP bill was passed and an act came into enforce. Everyone knows that Mr. Rajiv Chandrasekharan and Ashwini Vaishnav, they were the key people who introduced the bill and ensured that the act is passed. However, there are two unsung heroes. First time data privacy bill was tabled in the parliament was the year 2006. Mr. Dayanidhi Maran was the Minister of IT. And also in the year 2017, P.P. Chowdhury, Minister of State from Pali constituency, on 27th or 24th of August 2017, he tabled and he announced that privacy is a constitutionally protected right of every individual. And thus, in the year 2008, PDP bill was introduced. So these are the key insights which I thought I should share, including names of two unsung heroes who are also the part and parcel who gave us this beautiful DPDP Act. It talks about importance of privacy, it talks about the guidelines for data handling, adapting to compliance, risks of non-compliance on data fiduciaries or companies who are processing digital information and building customer trust. We will take this on our slides ahead. Right. So what are the key provisions to the DPDP Act? Typically in India, we have the habit of handling too much information or taking too much information. DPDP Act was very nicely articulated, very nicely documented, which ensured that only the lawful processing of the data, it is based on consent and with interest, legitimate interest. Only they are the people who are processing the data. Data minimization, unnecessary organization should not, and we as an individual should not share any data. Even the government brought the rules accordingly. Reporting of breach for any data loss, grievance addressals.
Sri Krishna, can I just interrupt? People are finding it difficult to hear. Please, you need to be a little bit louder, please.
Sure. Okay. The formation of data protection board, the consent mechanisms, right to access and accountability measures. I will take this all in the next slides, right? Wherein we start with data principle, because the few roles are classically being defined, which are data principals, data fiduciary, and data processor. Data principal is someone like you and me who got key importance as per the DPDP Act. This refers to any individual of whom the personal data is being processed, right? Like I said, this is you and me, and in case our value for breach of our data, the penalty is to the tune of 200 crores. In case, 250 crores. In case non-notification to the board and to the data principal of the data breach is in tune of around 200 crores. Data fiduciary is someone who is processing large amount of data. For simplicity, we will say bank, insurance companies, NGOs who are actually processing the child data and disabled people's information. They are termed as data fiduciaries because they are the one who are processing all our data. In case of failure of not applying controls to protect our data, the penalty is in tune of 250 crores. Data processor is a third party. Typically, insurance policies are printed by a third party agent, not by our insurance company. Right? A lot of data is being shared. Here, data processor need to ensure that adequate controls are being deployed, and it is the duty of the data fiduciary to ensure that controls are adequately being implemented. Though there is no penalty on a data fiduciary, data processor, however, it is the responsibility of the data fiduciary to ensure controls are being implemented. So penalty is again on data fiduciary. So for non-compliance of duties of the data principal, penalty is in the tune of 10,000 rupees. Right? Understanding the responsibilities of data fiduciary, because data fiduciary is someone which is very important in this DPDP Act. It is informed consent is essential before processing the data. Again, like I said, banks, high-tech companies, NGOs, they are the people who are basically termed as, or who can be classified as data fiduciaries, right? So consent needs to be taken prior to processing any personal data, right? Consent is for the act. Say we opening a bank account, a clear consent has to be provided by us, and a clear consent has to be recorded by the banks as well. That for what purpose they are taking the personal information. Implement data protection measures to safeguard. They need to ensure that adequate controls are implemented. Now, these controls can be protective controls, these can be detective controls, and monitoring controls as well. Even they need to ensure that the companies are being audited rightly at a periodic intervals as well. So here, any company can be a data fiduciary who's processing any personal information. Basically, DPDP Act is applicable to any company which is registered in India, even a smaller chartered accountant company who is actually processing personal information or who is in possession of personal information. They need to ensure that DPDP Act is implemented or controls are implemented because they can be data fiduciaries as well. Right? The third is respond promptly to rights request from data principal. It is the right and request of data principal where now we have the right to know what is happening of our data. It is in case if any modifications are being done, it is the responsibility of the data fiduciary to notify us. If our data is being used for any additional purpose, be it for cross-sell purpose. We are opening a bank account and our data may be used for cross-selling to a similar insurance company, then it is our right that we have to get notified about data being shared across. Even in case we request for deletion of data or forget the data, right? The organizations, it is the responsibility and duty of an organization to notify us that our data has been deleted. Right? Recording maintenance is vital for compliance verification. Like I said, they need to get audited at periodic intervals. So records needs to be maintained. This is to ensure that whatever controls are being implemented, whatever data is in possession, right? So adequate measures are being taken across for that. So understanding what is the consent framework of DPDP Act. So consent has to be free, informed, and unbundled. There should not be any implied consent. Right? So these characteristics, they ensure that individuals fully understand for what they are giving consent to, right? So like I said, it should be unbundled. If we are opening a bank account, if we are providing any personal information to open our bank account, if they are going to use this for cross-sell purpose, say for credit cards, insurance or so they need to ensure that they are giving that entire details to us. The data principal must be informed about data processing. Like we should be informed for what our personal data is being processed. If they are sharing it for providing credit card information, we should be well in advance informed about it. Nowadays, if you, I'll give you a classic case. Uh, like even banks, they have started sharing some information that if they are using our data for cross-selling purpose, we get some notification emails about it, right? I am not going to name any bank or anyone, but this is what I have evidence. Consent is revocable at any time. Though we are providing consent, law specifies that consent should be taken at a timely manner, right? And it should be revoked. So in case we are withdrawing our consent whenever we choose, right? The companies, the data fiduciaries need to ensure that they are removing our data and they are providing us adequate information about the same. Organizations has to maintain proof of concept. However, they have to keep one record for them because it may be applicable for any government purpose as well. This framework is not to trouble any organizations. This trouble is to empower individuals. Like I said, first time, I am happy that I'm a data principal. So data principal rights is right to access. So individuals now have right to access their personal information, their personal data, which is held by any data fiduciary, right? With transparency of data handling. Right? Like we don't know when we go for buying an insurance policy, we don't know who are the people who are actually accessing our data. Here we have the right to get this right of correction in case if for any mistakes, in case of any updates, we have right of correction at any given point of time. Right of erasure is when we feel we no longer are dealing with that particular company, we have a right to ensure that we can erase our data, get our data erased from them. Even we can have nominations added up or bundled up in our personal data. And there is a grievance readdressal process as well being documented. So well documented, well formed act. The only act which I've seen which is covered in 33 pages, uh, wherein a personal data privacy is concerned. Even data processor, they have certain obligations which needs to be followed. They are acting on instructions. So data fiduciary, data processors principal responsibility is to act on the directions of data fiduciary to ensure compliance, to ensure adequate controls they are being implementing, to ensure that data of data principles is protected. Because data fiduciary plays a key role and it is the responsibility of the data fiduciary to ensure that the data processors are implementing adequate controls. It is the responsibility of the data processors to ensure that confidentiality and integrity of data is maintained and the principle of trust here is maintained as well. Subcontracting is restricted, however, only approved by data fiduciary. Data processors can further subcontract. So again, the transparency comes into play. And there are legal compliance, which needs to be followed by data processors as well. There will be a separate board which will be set by the DPDP Act. The board is called a Data Protection Board. Their responsibility is to monitoring compliance, ensuring that each and every organization is adhering to DPDP Act, the provisions of the Data Protection Act, holding grievances. So in case if data principals have any grievances, they will be addressing complaints of the data principals on misuse of the data being done. They have the investigating powers in case where data is being breached, and they have a powers to impose penalties. So what are the key steps or immediate actions which every organization should do? Like I said, any organization registered in India, they need to ensure that they are complying with DPDP Act. First is they need to identify all the list of data sources. Now, this list is be it applications, be it APIs, be it servers, be it desktops, or any data points where digital personal data lies across. Right. They need to structure in a documented forms and schemas about it. They need to visualize on how the data moves, typically a process maps, right? How the data is moving across the systems, how the data is moving across the processes, what are the various touch points, right? In case if data is going to any third party, then how that data is being shared across to the third party. What are the existing controls which are being deployed across? What are the mitigating, what form of data it is going, right? Are there any adequate monitoring and detective controls being placed into? So data inventorization and data process maps plays a key role of identifying identifying the data, documenting the data, and identifying what the current controls are, and then is what are the additional controls which needs to be implemented, and where within the process monitoring controls needs to be deployed. My colleague Rachit will now take the way ahead.
Sure. Thank you so much. So before we start, I'll just pull up my screen. Okay. So thank you so much. During the earlier, slots wherein both of our speakers shared their perspective of how the DPDP Act came into the effect, the entire genesis and how, the DPDP is evolving. So they talked about consent, they talked about notices, and Medanshu also touched upon the volumes of personal data that we as a country are churning in and day out. Having said that, I would aim, to bring your focus to a very critical element, which, while we have already been talking about it, but with this DPDP Act coming in, it has become more of, importance, right? So that critical element that we are going to talk about is on the managing the third party risk in light of the DPDP Act, right? But before we start, I just want to show something to you. So this is the one. Yeah. So this is nothing but, an EV which is being juiced up by the chargers. But the idea of having this picture, this slide here is just to give you a context that how the entire ecosystem is evolving in case of the third parties or the critical supply people or the entities in your overall scheme of things. So these essential parties in your overall value chain are the third parties, right? With the advent of the EV focus across the world, so not in India, but abroad also, we are seeing the concept of smart chargers, right? Which are powering the electric cars. So these cars essentially are the end products but to enable their mobility, right? So a lot of other entities or other parties go into the overall scheme of things. So one of them will be your charging infrastructure. So what we have seen abroad is that there is a concept of smart chargers that have came in, right? So these smart chargers are essentially the IoT enabled devices, which of course have a dual purpose of charging your car. But having said that, in a quest to enhance the customer experience, they offer a lot of personalization in terms of how your charging pattern looks like, what are your preferences, and so on and so forth. In that quest, they also end up storing your cards under the feature of pay as you go, because you just come across, swipe your card, and charge your cars to a certain kilowatts. Imagine these car manufacturers, they are not building those chargers, but these chargers act as a essential component to the overall mobility. Now if these chargers are not well protected, right, having IoT enabled, what happens is that if these chargers are not protected well, so there is a every possible possibility that these chargers can be compromised over the air, and all your personal information which is hosted on the chargers or their backend infrastructure is at stake, right? So the whole idea of presenting this is to bring to a common ground where we should start thinking about where we are sharing our personal data and how the entities to whom we are sharing those personal data are handling these kind of critical details, right? So as we talked about, the third party risk management, it forms the very essential component, especially with the advent of this DPDP coming into the picture. Having said that, the concept of third party risk management, right, it is not new. All the entities, irrespective of their size, nature of businesses, right, they have been doing this third party risk management over a period of time. But why now it is of a more importance is that with the advent of this DPDP law coming into the picture, there is an importance that we tie some accountability to the third parties as well, whom we are entrusting, to protect or to handle our customers' data security. So there is a pressing need to revisit to, and if at all, if we do not have, then there is a need to build a strong third-party risk management framework. And I believe that one of our speakers already mentioned that it is not a question of when. So I think this is the time when we should start asking those right questions to our third-party suppliers, the third-party players in our overall value chain. Because one of the very important aspects which Mr. Dixit already highlighted is that irrespective of where the leakage happens, where the breach happens, right, the overall accountability or the overall responsibility lies with the data fiduciary. If you are a data fiduciary, then it is very important for you to tie those right accountabilities to your third party players in the overall value chain, right? This is how your third-party risk management framework should look like. Again, as I said, there is no right or wrong. There is no, apt or deficient third-party risk management framework. Lot of entities are putting a lot of efforts in managing their risks, including the third parties. But these form the core values of your, third-party risk management. So there is an importance at this point in time that you go back and revisit your overall third-party risk management framework and include the essential elements of vendor screening, their ongoing monitoring, their incident reporting, right? So whenever the incident happens at the third-party supplier, there is a need that it has to be reported well, and it has to be reported well in time. So all those protocols should be drawn up, right? That who will be overall responsible for communicating that incident, who will be communicating to the markets, and so on and so forth. So those responsibilities have to be fixed. then there is an importance to run periodic awareness programs with all your third-party suppliers. Right. So when we say that we have to conduct the onboarding screening of our vendors, so please note that one tool does not hold true for all kind of vendors, right? Each vendor who is rendering the service are different in the services that they are providing. So you cannot hold the same criteria for let's say a payroll partner, who is processing your sensitive data, vis-a-vis to a vendor who is supplying your furnitures or the cafeteria essentials to your entity. So there is a need to profile your third-party vendors, and where there is a possibility which involves a processing of a personal data, there is an importance that we have to conduct the thorough onboarding screening of the third-party suppliers. So there is an importance of conducting the thorough due diligence. It is also important to assess what kind of a control environment that the supplier has at its end, right? So we or you as a data fiduciary, right, have all the right intent to protect the customer information. But given the nature of the businesses, you end up outsourcing some critical components of your processes to a trusted third-party partners. So it is very important that they also echo the same commitment of protecting the customer's data, right? So that is very important that we also conduct the thorough review of their overall information security practices and how capable they are to handle our, the personal data of our customers. With this law, there is also a pressing need that we go back and review our standard master services agreements, right? This is the appropriate time that we should include all those relevant clauses which are explicitly called out in the data protection law, specifically the DPDP law. Needless to say, there is a requirement to do the continuous risk management or continuous risk assessments of all those critical or tier 1 vendors, right? So tier 1 I'm calling just for the sake of example, having so your entity needs to align to the overall risk management appetite, risk appetite, and the risk management framework, that what kind of a appetite you have and what kind of risk you will be able to tolerate, basis that you tier out your vendors. But the bottom line is that you should perform the periodic risk assessments. So it is not just at the time of onboarding, but recurrent in a recurrent fashion, you should conduct the risk assessments of all your critical vendors. The reason being that though your control environment is not changing, but our third-party suppliers are not controlled by our scheme of things. So their control environment is bound to evolve over a period of time. So that is where it becomes very important that you conduct periodic risk assessments of your vendors. As we talked about, there is also a very pressing requirement of doing the ongoing monitoring of our critical vendors. The important aspects of ongoing monitoring is periodic vendor audits. As a matter of fact, while during the onboarding, right, we end up signing the master services agreement, the performance agreements, and all those general legal terms. But having the clause of right to audit is often overlooked at, or at times the vendors don't agree to this. This is the time when we should start focusing, and we should be enforcing that kind of a clauses in our standard contracts. If it is a critical vendor, there has to be a right of audit clause that has to be built in those negotiated contracts. And those audits should also focus on what control environment or what technical controls are being evaluated. So that is very important. Second is introduction of the data privacy impacts assessment. So this is the time where we should include this as a part of overall risk management framework of the entity, that whenever we are onboarding a critical vendor, there has to be a data privacy impact assessment that needs to be done. The responses have to be captured, and at the end of the assessment, the risks have to be called out and those risks have to be managed. It is now no longer a free scout for the third party vendors. With this law, accountability has to be fixed. Right? As we said, my intent to discuss is just to provoke those thoughts, right? So that we should go back. We as the industry, we should go back and start thinking about all those questions which we have not been asking so far, right? Then there is also a concept that is being introduced. Even GDPR also has this concept, and DPDP also has this concept of privacy by design, right? Many a times we construe that privacy by design means developing those technical measures in your system, such as masking your personal information and truncating all those card numbers. So that is something which has to be done. That's a non-negotiable. That's a given thing. However, privacy by design also percolates to your overall contracts also. As we said, that right to audit, introduction of DPDP or privacy clauses into your standard contracts, that also forms as a part of privacy by design, because you are now embedding the privacy into the culture, and there could not be a better time than this to do all these things, because these are rules agnostic. So whenever the final version of the rules will be out, it does not has anything to do with that kind of a thing. This is the time where you can start building those things, so that once this final versions are out, so there is some amount of readiness in your overall privacy programs that you can directly leverage, right? We also spoke about how the incidents should be managed, right? Given the amount of personal data that is being churned out, Medhanshu already talked about, and he also related it to the GDP numbers. So you can imagine the quantum of the data that has been churning out day in and day out, and that also includes the personal data. So when this data is involved and technical systems are concerned, there is every possibility that the leakages or slippages will occur. So there is no shying away from that array incident ho gaya, what we should now be doing. No. See, incidents will happen, leakages will happen, slippages will happen. What is important is that you communicate those incidents, you report those incidents well. So your arrangements with your vendor should also focus on how the incident reporting has to be done by your vendors, right? There has to be a agreed upon steps what will entail in case of an incident that has happened, right? There also have to be a closely drawn up strategy that who will go to the market and communicate it, just in case if it is relevant to communicate it to the data principals, because a lot of parties are involved in that. So this is the time when we should start thinking about it, right? And mind you, when we say that incident response in light of DPDP compliance, so this is not something which should run in silos, right? This has to be integrated, or this should be talking to your crisis management plans as well, right? Because your crisis management plan also talks about how the communication has to be done. So what I'm trying to is connect all those dots into one scheme of things, wherein this forms as a part of all integrated risk management, which includes the privacy, cyber security, your operational risk, everything. So it is not something which has to be done in the silos, right? So that is why this incident response should also tie back to your crisis management plan, right? Now, in order to summarize what we just talked about and how we should start thinking about our renewed third-party risk management framework. So these are few summarized, things which we should be doing, right? First of all, we need to revisit our contracts with our critical vendors, include the DPDP clauses, start conducting the risk assessments before we onboard a vendor, right? Then there is a need, then we discussed there is a need for ongoing compliance that has to be tested. Of course, we just talked about the incident management protocols that have to be put into the perspective. And depending on your business, depending on your overall business, there could also be an opportunity where you can run the training and awareness programs for your vendors also, so as to communicate that what are your priorities in terms of customer data handling, and that should be well cascaded to your third party suppliers as well. Okay. So before I hand it over back to Prashant, right, I just want to leave you with one of the thoughts, right? Not necessarily you have to answer it, but just think about it, give it a thought, and start asking those right questions, right? Okay. All of us are using smart TVs in some form or the others, or some IoT devices which stream our favorite web series or the contents into our televisions, right? Have you observed sometimes that depending on the content that you consume, the next time that you switch on your TVs or the devices, you start to see all those relevant contents or the same category of content that you have consumed in some form or the other, in your smart devices, in your smart TVs, right? So what happens is that all these smart devices, they are also communicating that data back to your OEMs, right? The entities which are developing these smart devices. While we falsely, can imagine this as a personalization, but it is not. It is profiling that is being done, and our data is being used, and it is given back to the vendors so that they can show up the targeted ads or the contents to you. Because for all these manufacturers, personal data is the money and you are the product, right? So why this is important, right, at this point in time, is that we should start asking that why our data is being collected. Because in case of smart TVs, mind you, it is not the consent that you have given at first point in time, right? The only consent that you have given is in the form of checkbox that you have clicked, that I agree to the terms and conditions, but you never end up reading the fine prints, right? What happens is that they take that consent as an implied consent, and that is being used for some other purposes apart from the core purpose for which you have shared your consent. This is the time when we should start asking all those questions to whom we are sharing our data, right? So that is why it is important to provoke these things into our thoughts. And this is not, so smart devices is just one of the examples, right? There are several other examples in our day-to-day lives. Very relevant example could be your society RWAs, right? Many RWAs have implemented visitor management systems, right, which allow entries and so on and so forth. What happens is that we freely give our data to those entities in the name of registering the residents. What happens is that they take the entire dump of data, hand it over to somebody, some third parties, and then you start getting all those irrelevant calls. This is the time when we should start asking those questions, that why this data is needed, what is the purpose for which this is being collected, what if I want to withdraw my consent, so on and so forth. That was my whole idea of, to get you started thinking about how the personal data or the privacy can be well managed. With this, I hand it over to Prashant for the final proceedings.
Thank you, Rachit. May I request to just stop sharing your screen? Thank you. Thank you, Vedanshu, Shri, Rachit, for your thoughts and experiences. I think we have covered a lot today, from legal side of things to practical steps around data security and compliance. Actually, we have received a lot of great questions. Let us take some of them in the interest of time. So the first question is by Saurabh. He is asking, as DPDP Act places a lot of reliance on consent as a legal base for processing personal data. Would the consent work in a similar way as it works under GDPR? What will happen if the data principal revoke his or her consent for processing personal data? Is the data fiduciary obliged to delete the personal data of such individual?
Okay, so I'll take this question, Prashant. In order to answer this question, the first fragment of this question is, would the consent work in similar way as it works under GDPR? The answer is yes, because the overall premise of this act is the intent is same as what we are seeing in GDPR or any other data privacy regulations, right? So the answer to first part of question is yes. Second is, what happens if a data principal revokes his or her consent for processing personal data? Is data fiduciary obliged to delete the personal data? The answer to this is yes, because this act clearly calls out the responsibilities of data fiduciaries in parlance to the rights of the data principal. So if data principal says that, I want to exercise my right to be forgotten, right? The systems at the data fiduciary end should be capable enough that they should honor that requirement. Yeah, Medanshu, please.
So on this aspect of withdrawal of consent, I think I have a contrarian opinion here. Because if you look into the wording of the act, what it actually says is that, yes, data principal has the right to withdraw consent. But what it actually says is that the data fiduciary has to stop processing from the time that consent is withdrawal, and any action that is done prior to withdrawal of the consent, that will be valid in the eyes of law. It doesn't actually say that the data has to be necessarily deleted. So, I mean, you can draw a de facto conclusion here that unless and until the grounds are covered under the legitimate uses under sections 17 or 7, I think, unless and until you got it covered there, for example, to comply with a legal obligation where you have to store the data. So in that case, you will have to retain the data, but otherwise, yeah, a de facto conclusion can be drawn that it has to be deleted, but the act doesn't actually spell it out in as many words.
Okay. The second question is by Bhavani. He's asking that how's reinsurer covered under DPDP Act? Whether reinsurers are considered as data fiduciaries or data processors?
Okay, I will answer this, Prashant. Answer is partially they are considered as data fiduciaries, right? However, mostly they are data processors, because it is insurance companies are the data fiduciaries, and while they are reinsuring, right, their claims, so it is the reinsurance companies become the data processors. However, since they hold the key digital data as well, the digital personal data, it is their responsibility to ensure that content is secure, adequate controls are being deployed. The only reason is they will not be directly termed as significant data fiduciary, but they can be covered as data fiduciaries.
Okay. There is one question by Arpan Kumar Singh, and the question is, what does the Act say about cross-border data transfers and hosting data outside India? What is the role of consent managers and how do they integrate with existing IT systems?
Let me take the first thread of that around the cross-border, and I will leave Rachita Sri Krishna to respond to the other part. But as far as the cross-border transfers are concerned, right now I think the act has very rudimentary clause in the sense that the central government can, by notification, list out the countries to which the transfer will be prohibited, or indirectly it will be allowed. So we'll really have to wait for the rules and notifications to see which countries will be allowed. I think the government will apply some kind of standards of bilateral treaties maybe, or equivalent protection that is afforded in the other jurisdictions. So those kind of standards might be applied, but that's all that we know as at this point of time regarding cross-border transfers.
Okay, and the second part was, what is the role of consent managers and how do they integrate with existing IT systems?
Okay, so Prashant, I'll try to answer this. What is the role of consent manager, right? So this is a concept that has been coined in this act. So consent manager, as it is clear from the name, it is something which has been entrusted with managing the overall life cycle of the consent, right? It can be a technical system. It cannot be a technical system, right? It's a phenomena that has to be built into your overall scheme of things. But the bottom line is that your systems should be capable enough to record the consent which is freely given, which is impartial, and it is unbundled consent. So your system should be able to record the consent. Your system should be able to retain the consent till the time of purposeful processing, that we call it as in parlance of this act, right? And when the time is apt, or that life cycle ends, or if the data principal wants to withdraw the consent, your system should be capable enough to allow the data principal to do that. So as I said, it could be built as a technical capability into the systems. It can be integrated into your systems because a lot of R&D is being done in that front. But having said that, it does not necessarily talk about whether it has to be technical or it has to be a manual phenomena. But of course, the consents have to be managed end to end, right from obtaining the consent to the revocation of those consents.
Okay. There is very interesting question by Alka, and she's asking that please share key tips to ensure DPDP Act compliance while using solutions.
Okay, I will answer this interesting question. Thanks, Alka, for asking this personally. While using Gen AI-based solutions, you need to ensure that you are implementing adequate measures. Right? There are controls in place where you need to enable those, which says that your data is not being fetched outside. Right? It is helping your Gen AI to implement it in your local systems and helping you to comply or helping you to develop your own LLMs. Right? This is the first one. And also to add up is you need to ensure you are following laws of land, which talks about data localization. You need to ensure you are not sharing, because unless and until you are not implementing those controls on Gen AI, you will be exposed of sharing your client data or your organization's data in public domain as well. Right? These are few controls which you need to ensure that you are implementing it.
Okay. We have almost exceeded the time allocated for this webinar. So in the interest of time, we may not be able to all address all the questions live here, but rest will make every effort with responses after the webinar. Thank you all for joining today's session. A special thanks to all the speakers for sharing their expert perspectives. We'll be sharing the recording, a summary of the webinar, and the contact details with you shortly. You may reach out to us with your questions or any follow-ups that you may wish to have. Have a great day ahead. Thank you so much for joining.
Thank you.
Thank you very much.